asking council to stipulate that TML has been provided with notice in this matter, in this hearing, as witnessed by the fact that he is here. Council, we so stipulate?
So stipulated, Your Honor.
And Mr. and Mrs. Nolan, seeing that you are here today, you too received notice of this hearing and you are here, is that correct?
That's correct.
All right, thank you. Let us start with the substance of the complaint. Mr. Farinacci, do you wish that we waive the reading of the complaint?
Your Honor, counsel has had the opportunity to go over the complaint with the minor child, and we waive reading at this time.
Thank you. We will not read the complaint in its entirety, but the complaint consists of 6 counts. The first 3 counts are counts alleging aggravated murder, an unclassified felony if committed by an adult. The 4th and 5th count are attempted aggravated murder, a felony of the 1st degree if committed by an adult. And the 6th count is felonious assault, a felony of the 2nd degree if committed by an adult. Council, have you had an opportunity to review the Geauga County's Acknowledgement of Rights and Consequences form that was passed out?
Yes, Your Honor, I have.
All right.
I've also reviewed those rights with the grandparents, and their signature has been obtained.
All right, then we will go through briefly the rights of the parties in this matter. Let me first of all start with TML. TML, you have a right to be represented by counsel at all times during these proceedings. You are being represented by attorneys Tolson, Farinacci, and Lavelle. Is that correct?
That is correct, sir.
To Mr. and Mrs. Nolan, you also have a right to be represented by counsel in these proceedings. Do you wish to be represented by counsel at this time?
Not at this time, Your Honor.
Okay. The court will note that you reserve that right in any other future proceeding if you so wish. TML, you have a right to receive a copy of the complaint, and as acknowledged by your attorney, you have seen the complaint and have waived the reading of the charges, but you are aware of the 6 charges that have been brought against you?
Yes, I am, Your Honor.
You have a right to have a trial on those charges, and at that trial, you have a right to require that the state of Ohio prove each element of each charge at trial beyond a reasonable doubt if the state can do so. Do you understand?
Yes, I do, Your Honor.
You have a right not to testify against yourself. At trial, you can remain totally silent, and your silence cannot be used against you. Do you understand?
Yes, sir.
You have a right to confront and cross-examine any witness that testifies against you at trial. Do you understand?
I understand.
You have the right to compel the witnesses to appear and to testify on your behalf at trial. Do you understand?
Yes, I do, sir.
You also have the right to offer evidence and dispute any evidence offered by the state of Ohio at trial. Do you understand?
I understand.
And you have a right to be put in jeopardy, which means you can only be tried once for each of those offenses charged, and if the state fails to meet their burden of proof beyond a reasonable doubt, you cannot be tried a second time for those charges. Do you understand?
Yes, Your Honor.
You also have a right to be considered under our legal system innocent until the charges have been adjudicated and the state proves otherwise if the state can do so. You understand that as of today, under our legal system, you are deemed to be innocent until found otherwise?
Yes, I do.
You also have a right to appeal to a higher court if you believe that this court has made any error, and that court would be the 11th District Court of Appeals. And if such appeal is taken, you have a right to a copy of the record of all proceedings provided to you at the public expense if you cannot afford to do so. Do you understand?
I understand.
At this time, I'm going to ask the Chief Deputy Clerk to go ahead and circulate the acknowledgement form. For the benefit of those here, this form is a written acknowledgement by TML3 and the legal guardians that they have been advised of the rights that TML has throughout the proceedings, including the possible consequences. In this case, the consequence being either a bind over under Juvenile Rule 30 if probable cause is determined, or to be subject to placement in the Department of Youth Services, detention, and other penalties if the matter would remain in the juvenile court.